You're listening to the Bare Metal Cyber Prepcast, created to help you succeed in your educational journey. Learn more at baremetalcyber.com, where additional prepcasts, books, and training materials await. Let's get started. The Family Educational Rights and Privacy Act, or FERPA, was enacted in 1974 to protect the privacy of student education records and to give parents, and later students themselves, meaningful rights over access and disclosure. FERPA applies to all education agencies and institutions that receive funding under programs administered by the U.S. Department of Education, making it nearly universal across public K-12 schools and higher education institutions. For learners, FERPA stands as the foundational U.S. privacy law in the education sector. It reflects the recognition that education records contain sensitive information, from grades and disciplinary history to financial aid details, and that mishandling such data can affect students' futures. FERPA therefore builds accountability into how institutions collect, store, and share records, while balancing operational needs for education delivery and oversight. The scope of FERPA revolves around the definition of education records. These are records that are directly related to a student and maintained by an educational agency or institution or by a party acting on its behalf. The breadth of this definition means that transcripts, report cards, disciplinary files, and financial aid documents all qualify. However, there are key exclusions, such as law enforcement unit records, sole possession notes, and certain treatment records, which are considered outside FERPA's scope. For learners, the definition and its exclusions highlight the importance of boundaries. Not all information maintained by a school qualifies as an education record, and understanding where FERPA applies is the first step in determining whether protections attach. Personally identifiable information, or PII, is the lifeblood of FERPA's protections. PII includes obvious elements such as a student's name, Social Security number, and student ID, but also indirect identifiers like date of birth, mother's maiden name, or other data points that could reasonably identify a student. This expansive definition reflects the reality that re-identification can occur through combinations of information, not just singular details. For learners, PII under FERPA illustrates how privacy law adapts to context. Education records are rich with identifiers, and protecting them requires vigilance across multiple dimensions of information, not only the most obvious identifiers. Parents hold the rights under FERPA for students in K-12 settings, but those rights transfer to the student upon turning 18 or enrolling in post-secondary education, at which point the student becomes an, quote, eligible student. This transition underscores FERPA's recognition of evolving autonomy. For learners, this shift demonstrates how privacy rights are designed to align with maturity and independence. Institutions must have clear processes to manage the transfer of rights, ensuring that records access, consent requirements, and disclosure rules reflect the appropriate rights holder at each stage of the educational journey. The right to inspect and review education records is one of FERPA's core guarantees. Parents or eligible students must be given access within 45 days of a request, with institutions prohibited from charging unreasonable fees that would impede access. This right empowers individuals to understand what information is being maintained, verify its accuracy, and use it to advocate for themselves. For learners, access rights highlight transparency as a central privacy principle. Education records directly influence opportunities, so ensuring individuals can review them prevents hidden decisions from shaping student trajectories without accountability. FERPA also provides the right to request amendment of education records that are inaccurate, misleading, or otherwise in violation of a student's rights. Institutions must consider these requests and either amend the record or provide a formal denial with reasons. For learners, the amendment right shows how FERPA extends beyond access into correction. It ensures that students are not disadvantaged by errors or unfair characterizations in records that may follow them into higher education, employment, or other opportunities. amendment reflects the principle of fairness in privacy law. Records should not only be transparent, but also accurate and reliable. If an amendment request is denied, FERPA requires institutions to provide hearing procedures. The hearing allows the parent or eligible student to present evidence and argue their case before an impartial officer. If the institution still refuses to amend the record, the student has the right to add a statement of disagreement that must be included whenever the record is disclosed. For learners, this provision illustrates due process in action. Privacy rights under FERPA are not static entitlements but include structured avenues for challenging and correcting decisions, reinforcing fairness and accountability in record-keeping. Institutions must also provide annual notification to parents and eligible students describing their rights under FERPA and the procedures for exercising them. This notification typically outlines access, amendment, consent, and complaint rights, along with institutional policies. For learners, the annual notice illustrates how awareness is built into compliance. Rights are only meaningful if individuals know they exist and understand how to use them. Annual notification reinforces transparency, ensuring that students and families are equipped to exercise their protections consistently. The prior written consent rule is perhaps the most recognizable feature of FERPA. Institutions may not disclose PII from education records without written consent from the parent or eligible student, unless a recognized exception applies. Consent must specify the records to be disclosed, the purpose, and the recipient. For learners, this rule demonstrates how FERPA establishes consent as the default baseline. It empowers individuals to control how their information is shared, creating a clear line between permissible and impermissible disclosures. An exception exists for directory information, which includes categories such as name, address, telephone number, date of birth, participation in activities, and other relatively low-risk identifiers. Institutions may designate directory information and disclose it without prior consent, provided they notify families annually and allow them to opt out. For learners, directory information shows how FERPA balances privacy with practicality. Certain information is routinely published, such as in sports rosters or graduation programs. The opt-out option preserves autonomy while allowing schools to operate effectively. The school official exception allows disclosure of education records without consent to school officials with legitimate educational interests. This includes teachers, administrators, or contractors who need the information to perform their job responsibilities. For learners, this exception demonstrates FERPA's pragmatism. Education requires collaboration, and prohibiting internal sharing would paralyze operations. The key is limiting disclosures to legitimate educational needs, ensuring that records are not accessed out of curiosity or convenience. FERPA permits disclosures for audit, evaluation, and compliance purposes to authorized officials such as state or federal education authorities. These disclosures ensure that education programs are being administered lawfully and effectively. For learners, this reflects how privacy rights coexist with oversight. Institutions are accountable not only to students and families, but also to regulators who monitor program quality and compliance with federal standards. The studies exception allows disclosures to organizations conducting research for or on behalf of educational institutions, provided that PII is used only for specified purposes, protected from unauthorized disclosure, and destroyed when no longer needed. For learners, this illustrates how FERPA balances privacy with innovation. Research supports better educational practices and policy, but it must be conducted within guardrails that minimize risks to student privacy. FERPA also includes a health and safety emergency exception. Institutions may disclose PII without consent if necessary to protect the health or safety of students or others. Disclosures must be limited to the duration of the emergency and to parties who can address it. For learners, this highlights the principle of proportionality. Privacy is a strong default, but it yields to urgent needs where disclosure prevents harm. This exception ensures flexibility without undermining overall protections. Finally, institutions must maintain a record of disclosures, documenting when and to whom PII was released and under what authority. Redisclosure is tightly limited, with recipients prohibited from passing on information without consent unless an exception applies. For learners, this requirement ensures accountability and auditability. It provides transparency into data flows and discourages casual or unauthorized redistribution of sensitive education records. For more cyber-related content and books, please check out cyberauthor.me. Also, there are other prepcasts on cybersecurity and more at baremetalcyber.com. Law enforcement unit records are expressly excluded from FERPA's definition of education records. Schools may maintain records created and held by campus police or other security units for law enforcement purposes, without bringing them under FERPA protections. This means those records may be shared more freely with outside law enforcement agencies. For learners, this exclusion underscores the distinction between education and public safety functions. Records tied to classroom performance or student discipline are protected, while those created for law enforcement purposes remain outside FERPA's scope to ensure security responsibilities are not impeded. Sole possession notes are another exclusion, referring to personal notes kept by educators as memory aids. These notes must be kept in the sole possession of the maker and not shared with others to remain outside FERPA. For learners, this exclusion demonstrates FERPA's practical boundaries. Educators may jot personal reminders that help them manage classes without creating formal education records. But once notes are shared or maintained institutionally, they lose this exclusion and may become subject to FERPA's protections. Treatment records, typically held by health professionals providing services to students, are excluded from FERPA so long as they are used only for treatment. However, if disclosed to others for non-treatment purposes such as academic accommodations, they become education records and thus fall under FERPA. For learners, this shows how FERPA flexes based on use. Confidentiality for treatment is preserved, but once information influences broader institutional functions, FERPA ensures protections follow. Subpoenas and court orders create another pathway for disclosure. FERPA allows institutions to comply with judicial demands for records, but they must make reasonable efforts to notify the parent or eligible student in advance, unless specifically prohibited by the court. For learners, this illustrates FERPA's balance between legal process and individual rights. Disclosure is sometimes necessary, but transparency about that disclosure ensures individuals are not blindsided when their records are sought. In litigation contexts, FERPA applies additional protective measures. Courts may issue protective orders, limiting how records are used, shared, or disclosed to maintain confidentiality. For learners, this reflects FERPA's adaptability to adversarial proceedings. Student records may be relevant in disputes, but their exposure must remain controlled to preserve the privacy interests the law seeks to protect. FERPA also allows for de-identification of student data, enabling institutions to share information once all personally identifiable details have been removed. Schools must use a reasonable determination standard to ensure that students cannot be re-identified, even indirectly. For learners, this standard emphasizes careful analysis of data release. De-identification is not simply redacting names, but evaluating the dataset holistically to prevent linkage back to individuals through combinations of attributes. Biometric records, such as fingerprints, facial templates, or voice prints, fall squarely within FERPA's definition of personally identifiable information. As schools increasingly adopt biometric technologies for attendance or security, these identifiers must be handled with the same care as traditional PII. For learners, this demonstrates FERPA's evolving scope. Privacy protections are not frozen in 1974, but apply to modern technologies that uniquely identify students, reinforcing that principles of consent and limited disclosure extend to biometric innovations. Student identifiers and email addresses also require careful handling. Some institutions designate these as directory information, which may be disclosed unless parents or eligible students opt out. Others treat them as sensitive identifiers, limiting use to internal contexts. For learners, this illustrates how FERPA offers institutional discretion within boundaries. The key is ensuring transparency through notice and respecting opt-out choices to prevent unintended exposure of identifiers. Online service providers used by schools may be considered school officials under FERPA if they perform institutional services under direct control of the school. Written agreements must limit their use, disclosure, and retention of student information. For learners, this shows how FERPA extends protections into outsourced services, ensuring cloud providers, EdTech vendors, and testing platforms operate under the same obligations as in-house staff. Control through contracts becomes the linchpin for compliance in digital learning environments. Outsourced educational services contracts more broadly must reflect FERPA's limits, specifying that vendors may only use student information for contracted purposes, must maintain confidentiality, and must destroy data when services end. For learners, this highlights the role of contract law in operationalizing privacy. FERPA sets the principles, but institutions enforce them through detailed agreements that govern how third parties handle sensitive student data. State longitudinal data systems, which link student data across agencies to evaluate educational outcomes, create additional complexities. FERPA permits interagency sharing for audit, evaluation, and research purposes, but requires governance structures to prevent misuse. For learners, this illustrates how privacy must coexist with public accountability. Longitudinal systems provide valuable insights, but only when paired with strong safeguards, access controls, and transparency to maintain public trust. Research disclosures under FERPA require that recipient organizations use the information only for the specified study, protect it from unauthorized use, and destroy it when no longer needed. Oversight by the disclosing institution ensures compliance. For learners, this provision highlights FERPA's careful balance between advancing knowledge and protecting privacy. Research is vital to improving education, but it must not come at the cost of exposing student records unnecessarily. The Student Privacy Policy Office, SPPO, part of the U.S. Department of Education, administers FERPA enforcement. Parents and students can file complaints with SPPO if they believe their rights have been violated. Enforcement often results in guidance, corrective actions, or, in rare cases, withdrawal of federal funding. For learners, SPPO's role emphasizes that FERPA compliance is not purely theoretical. Institutions face real accountability, with oversight designed to correct deficiencies and reinforce student privacy protections. FERPA also interacts with the Children's Online Privacy Protection Act, COPPA. In K-12 settings, schools may provide consent on behalf of parents for online services used for educational purposes. However, that consent is limited to educational contexts and does not grant providers the right to use data for commercial purposes. For learners, this interplay illustrates how multiple privacy frameworks intersect in schools. FERPA governs education records broadly, while COPPA governs online collection from children under 13, together creating layered protections in digital learning. In conclusion, FERPA establishes a robust framework for student privacy built on consent defaults, defined exceptions, and documented disclosure controls. It gives parents and eligible students rights to access, amend, and control their records, while allowing institutions flexibility to support education, research, and safety. For learners, the enduring lesson is that FERPA reflects the delicate balance between individual rights and institutional needs. By embedding transparency, accountability, and consent into education record handling, FERPA ensures that privacy remains a central value in the pursuit of learning. Thanks for tuning in to the Bare Metal Cyber Prepcast, your trusted source for cybersecurity news and insights. Remember to subscribe at baremetalcyber.com so you never miss an update. And visit cyberauthor.me for best-selling cybersecurity books that equip you with expert knowledge. Until next time, stay secure and stay vigilant.